What are the main types of bankruptcy law cases? If you are curious about the different types of bankruptcy law cases, you are in the right place. Understanding these types is essential, especially if you are considering a career in bankruptcy law or hiring a bankruptcy law firm. Bankruptcy law cases primarily fall into four main categories, each defined by specific chapters of the Federal Bankruptcy Code. First, we have Chapter 7 Bankruptcy. This is the most common type filed by individuals. It involves liquidation, where the bankruptcy court sells the debtor's non-exempt assets to pay creditors. To qualify for Chapter 7, individuals must meet certain income requirements. After the liquidation, remaining qualifying debts are usually discharged, relieving the debtor from personal liability. This option is often chosen by those with limited income who cannot realistically repay their debts. Next is Chapter 11 Bankruptcy. This type is primarily used by corporations and businesses. It allows them to continue operating while restructuring their debts. The debtor proposes a plan to reorganize finances and pay creditors over time. Although this process can be more complex and costly, it is also available to individuals with substantial debts who need flexible repayment options. Then we have Chapter 12 Bankruptcy, which is designed specifically for family farmers and fishermen. This type offers a streamlined reorganization process, allowing debtors to keep their property and work out a repayment plan with creditors. This reflects the unique financial cycles and challenges faced in agriculture and fishing industries. Lastly, we have Chapter 13 Bankruptcy. This type is for individuals with a regular income who want to keep their property while repaying debts over 3 to 5 years. It involves a court-approved repayment plan that helps debtors catch up on missed payments, avoid foreclosure, and manage debts in an orderly manner. For law students interested in bankruptcy law, knowing these types is essential. Each type involves different procedural rules, debtor protections, and creditor rights. Understanding filing requirements and automatic stay provisions, which halt creditor collection efforts upon filing, is key. Litigation in bankruptcy courts can resemble civil litigation, involving discovery, pretrial motions, settlements, and trials over disputes like property ownership and debt amounts. For those pursuing a career in bankruptcy law firms, mastering these types and their procedural frameworks can impact client outcomes and hiring prospects. Bankruptcy law firms often look for candidates who can navigate complex cases and manage creditor-debtor conflicts effectively. Knowing the main types of bankruptcy law cases can set you apart in this competitive field.